Okay, well, I guess we'll get started here. Thanks everybody for coming. This is evaluating and amending your zoning law live at the Loudville Municipal Building. We've got a handful of folks here in person, all socially distanced and taking the proper COVID cautions. So thanks everybody for doing that. Just wondering that the people here are you planning board people, mostly ZBA planning board.
Yeah,
Town board. So we got a good mix. We've got 30 some people on Zoom also.
That is true.
So
50.
So welcome to them. Hopefully you can hear me and see my presentation. So we will get started here. Hopefully this won't take too long. I know people probably want to go watch the debate later. So, well, so we'll see what we can do here. My name is Matt Johnson. I'm the Director of Planning at the Tug Hill Commission. I've been at the Tug Hill Commission a long time, I think 26 years coming up. Before that, I worked briefly at the St. Lawrence County Planning Office. I spent a lot of time in this room doing zoning amendments for the village of Loudville. So I'm pretty familiar with this part of Tug Hill. With me tonight, I've got Elena Millette.
Everybody?
Over behind the camera, and she's going to be sort of taking care of the Zoom aspect of this and working the camera. This is a new presentation for us, so thanks everybody for being part of this. I'm kind of taking inspiration here from a presentation Mark Gibo did at the local government conference 4 or 5 years ago. And also the Department of State has some great materials, and a great paper on this very subject. So thanks to both of them. We'll do questions, I guess, afterwards. If you got something really pressing, go ahead and shout it out. But we've got this, trying to figure out how to do this thing with Zoom and in person, so bear with us on that. We do have training certificates for everybody here tonight, paper copies, I believe. And everybody on Zoom, we will email you your copies shortly. I just hit the wrong button. So zoning, why are we here? What's the purpose of zoning? Zoning is intended to protect the public health, safety, and welfare in your community. And it does that by regulating land use, density of development, and placement of structures on lots. Those are the three big things that zoning does. So if your community wants to do that or is doing that, one, two, or all of those things, you really should be doing that through a zoning law. There's ways to do some of that without a zoning law, but we really recommend that you adopt a full zoning law under the New York State statutes. So the authority to do zoning in New York State comes from the statutes, in particular town law, village law, and municipal home rule law. We're kind of gearing this presentation to towns and villages, since that's what we have in the Tug Hill region. We don't have any cities, but cities derive their zoning power from city law. And the town laws, village law, city law are very similar, but there are some minor differences for cities, and we won't go into those tonight, but cities are a little bit different in some ways. Municipal home rule law also gives municipalities the power to regulate some of these things. There's a great resource from the Department of State if you want to read more about the planning laws. You can get it from the website, the blue link at the top of the slide. And it's called the Guide to Planning and Zoning Laws of New York State. And that's a PDF file that you can download for free. It's quite big, but you can bring it up online and print out your relevant sections. And if you're on a planning board or ZBA, town village board, and you're interested in planning, you really ought to download this and take a good look at the back, what's the framework within which we can do zoning. So what zoning can't do are a number of things. One of them is regulate interior space. We're not concerned with the design of the interiors of structures. It can't regulate ownership or be tied to ownership. Zoning really just concerns the land, and it's not about who is using it or owning it. A lot of times this will come up in communities where a town will want to maybe allow an extra dwelling on a single lot, and they'll want to allow it contingent upon it being owned by a relative of the owner of the lot. Somebody's son wants to build a house on the same lot, or somebody has a mother-in-law, whatnot, wants to live on the same lot. So towns and villages will want to limit that type of development to a family member, and you're really not supposed to be doing that. You're supposed to just regulate the land use only. Zoning can't control the market or competition. So zoning can't be concerned with how many drugstores there are in a village. A planning board can't disapprove an application based upon the fact that if we allow this, it's going to be competition for the long-standing store that's been in the village for years and years. Really not supposed to look at that. Again, just the land use and the land development. Zoning should be in accordance with the comprehensive plan. Is everybody familiar with the comprehensive plan? So that's basically a document that your community adopts that is vision for the community, and it sort of sets out policies for growth and development, orderly growth and development. It serves as the sort of the rationale for your zoning law, your subdivision law, some of your other laws. So whatever you do with your zoning law, that should not be wildly out of sync with your comprehensive plan. So when you amend your comprehensive plan, if you make big changes that are going to affect land use, you should really bring your zoning law back into accordance with your comp plan. Zoning should also implement a community vision and encouraging orderly growth. So there again, that's stated in the comp plan, but if you don't have a comprehensive plan, you're still trying to implement this planning vision and growth and development vision for your community. Zoning should also protect important resources. So those might be historic resources, historic structures and sites, scenic resources, nice views, and of course natural resources, your soils, your streams, your water bodies, things like that. Zoning should not create inequities. So you shouldn't be using zoning to, for instance, make it unaffordable for low-income people to move into town, build a house. We don't see a lot of that in Tug Hill, but this has been an issue in suburban, wealthier suburban areas that may want to adopt a very large lot size that makes cost of development prohibitive to certain types of, certain income groups. We don't want to do that. Zoning shouldn't stifle creativity. So your zoning shouldn't be so rigid that It's sort of requiring cookie cutter development that all looks the same and feels the same. It shouldn't be overly restrictive. So your zoning shouldn't be so, again, so rigid that you don't get a good variety of land uses. With this, you can start to get into trouble legally. You can get on shaky legal ground if you're being overly restrictive and taking, what they call taking people's property. So there again, we don't have much of an issue in the Tug Hill region with this, but something to think about when you're amending your zoning. A good zoning law should be clear, understandable, predictable, and effective. And we have lots of experience, I hope, writing that type of law. So there's lots of help out there for municipalities to accomplish that. The zoning law should be a living document. It should be periodically revised. It shouldn't just sit on the shelf and never change. How often you revise it, that really depends on what's going on in your community. We have towns that update their zoning every couple of years. We have towns and villages that haven't changed their zoning in, I don't know, 20 years. So it really depends. Really depends on how fast your town's developing, how complicated your town is. If you have state highways and waterfront areas and hamlets, you're probably going to get more development than if you are a very, very rural town. But it all depends on the town. So what are symptoms of poor performance of the zoning law? What are things that are happening that sort of indicate that you might want to evaluate and amend your law? One is you get an increase in variance and interpretation requests. So this is where you really have to ask your ZBA, know what's going on with your ZBA and your zoning enforcement officer. Are they all of a sudden getting all these requests for setback variances? Are they getting requests for interpretations because some of your definitions have kind of gone out of date and don't really make that much sense anymore? That's something you might see. You might see an increase in lawsuits. Hopefully that's not happening a lot. But that of course doesn't always happen because of problems with your zoning law. That happens for other reasons, but it may indicate that you've got something that's very out of whack in your zoning. Your zoning might be out of date in terms of the being in accordance with the statutes, or it might be out of date as far as new court decisions that have been rendered, and we'll get to that in a few slides. But if you're seeing a lawsuit or two more than you normally would, you need to take a look at your law. Back to the comp plan. Has your law become out of sync with the comp plan? As I mentioned earlier, if the comp plan has been amended recently and the zoning hasn't, that's something you should address. Or if the zoning has been amended and the comp plan hasn't been amended, then you want to change the comp plan. But the two of those should always be somewhat in sync. And that can be a little difficult because what you're really trying to do with the comp plan is be a little more general than the zoning. So you want your comp plan to be not so complicated and tied to the zoning that any little change in your zoning law requires a change to the comp plan. You want to have a little leeway in the comp plan so that you can change minor things in the zoning and still be in sync, if that makes sense. If you have an overabundance of nonconformities, that's an issue. And a good example of that is if you have in your zoning law for the entire town, a 1 acre minimum lot size. That works in some towns, but if you have a town that has a hamlet that has a lot of quarter acre lots, that's been there since the mid 1800s or whatever, late 1800s, you've got a hamlet with lots of quarter acre lots, narrow lots, 30-foot wide frontage lots. When you sort of go over the whole town with a 1 acre zoning, you're immediately creating a lot of nonconformities. So that can be an issue. Your law can be out of sync with the statutes. And that's generally the older laws that we see that have that issue. And I've got the picture of the typewriter here. If your zoning law was written on a typewriter, like that one, it's time to look at it. And we have a few communities in Tug Hill that do have typewriter written zoning laws. And that's not, I'm not shaming them, but and they may be working, they may be okay, but it's probably time to take a look at them. As far as the statutes go, in the early 90s, the early 1990s, some big changes were made, and some of those were changes to the time frames that are given to certain zoning decisions, the time within which you have to hold a public hearing, the time between the public hearing and the zoning decision. Those used to be 45 days in a lot of cases, now they're 62 days. So if your law still has the 45 days, that's something you probably want to change. A lot of times laws just get unwieldy and unorganized. I call that a Frankenstein law. And that happens when you just, over years and years and years, you make all of these piecemeal changes. And certain sections get amended and moved around, and you can get some redundancies. You can get a law that just doesn't work together, it doesn't flow. So in those cases, we want to hit the reset button and just kind of start over and reorganize everything, streamline everything. That doesn't happen a lot, but it does happen. And I think the last thing here, the zoning enforcement officer can't enforce the law. The ZEO is having a lot of trouble interpreting what the definitions mean, what the standards in the law are. They're too vague. Maybe it's the opposite, and they're so detailed that he or she is having trouble figuring them out and applying them in certain situations. That's something that you really need to keep in touch with your ZEO. Have them, talk to them at your town and village board meetings. Get their take on how the zoning law is working in your community. Some issues when we start to think about amending zoning. Does your law have not enough zones, or does it have too many zones? And this is often a balancing act to get the right number of zones. And a lot of times what will happen, a lot of our towns will start out, their first zoning they adopt will be what we call a one-zone zoning law. So they'll just have the whole community will be one zone, one unnamed zone, where all the uses are allowed, all the lot sizes, minimums are the same, all the dimensional requirements are the same. And that works for a lot of communities, especially ones that are very simple. We've got some towns in Tug Hill, maybe the town of Worth in Jefferson County, town of Steuben in Oneida County. These are towns that don't really have much in the way of hamlets. They don't have waterfront issues, they're pretty easy to just handle as one zone. We also have towns that, like I say, are new to zoning, and this is how they sort of get their feet wet with administering a zoning law. This is a really nice, simple way to do it. You know, decisions are a lot easier. Your zoning board of appeals doesn't have to handle use variance applications because all the uses are allowed. So all they deal with is area variances. It's a great way to sort of start with zoning in your community. The problem is that some communities just don't lend themselves to the one zone. Communities with hamlets, there again, you're creating those nonconformities. Communities with waterfront, little lakes with waterfront cottage development. Communities that just have a little more different types of development character areas. You probably want to at least add an overlay zone or add a couple new zones. The flip side of that is you have too many zones. Some communities have amended their zoning law over the years based on requests from the public or for whatever reason, and they tend to end up with 9 or 10 zones. Some end up with 4 or 5 different types of residential zones that really aren't that different from each other. And it's a case-by-case basis where some communities you want that, but in some that's kind of become a problem. So if you have 2 zones that are exactly the same, except for one of them allows maybe one more use than the other, or if you have 2 zones that are exactly the same, except for one has a half-acre minimum lot size and the other has a 3/4 acre minimum lot size, that's something you may want to take a look at, and you may be able to simplify your law. And that simplifies your zoning map. That gets rid of zoning district boundaries that may be hard to interpret. So that's one of the things that we look at. Also, your list of uses allowed, that might be too generic, that might be too minimal. A lot of simple zoning laws, they'll have just a commercial use designation and a residential use designation. And anything that's defined in the law as a commercial use falls under that allowable use. So when your town is growing, you could get into trouble, with, you're treating all kinds of different commercial uses, from a truck stop to a small retail business the same. So that's something that you may find yourself needing to break those out a little bit better. The flip side of that is you could have too detailed of a list of uses. You could be so specific in your use that the zoning enforcement officer is having a hard time figuring out what a use is. And an applicant is having a hard time figuring out what a use is. That can lead to problems. That can lead to requests for interpretations and lawsuits. So both of these things are really a balancing act. And how do you get it just right? Sometimes zoning changes are made necessary by court decisions and sometimes by new legislation. And these things happen periodically, and people like me try to stay ahead of these things, but sometimes we miss some of them, so we're doing our best to stay apprised of these. There's a lot of examples, but 2 I've listed here are signs and manufactured homes. And the regulatory landscape for those 2 things has changed a lot over the years. Sign regulations can be very complicated, and there really are a lot of restrictions on what communities can do as far as regulating signs. And probably the biggest thing to know these days, and it was really solidified by a Supreme Court decision from 2015, Reed versus Town of Gilbert, which was something that was happening, I think, Arizona. That basically solidifies the idea that you can't regulate based on content of sign. You can't differentiate between what a sign says in the way you're dealing with it, as far as what size it can be, where it can be on a lot, the design of it. You can regulate those things. You can regulate size, location, design, but you can't do so differently for different types of signs. So that's something that a lot of our communities have in their zoning that really should be looked at. A lot of our community zoning laws have different standards for political signs than they do for commercial signs. And there's a lot of reading material on that I can link you to, and we can certainly help you try to navigate through that. Another example is the manufactured homes. Communities have become much more restricted in what they can do as far as regulating the location of those. There was a 2015 legislation from the state that essentially says that if somebody wants to put a manufactured home on a fixed foundation, that manufactured home has to be treated just like a single-family dwelling. If it's on a permanent foundation and it is complies with the rest of your standards as far as lot size and setback, any standards like that, if it complies as a single-family dwelling does, it's got to be treated the same. A lot of villages in the North Country and in Tug Hill want to prohibit manufactured homes entirely. That's not uncommon. And we've known for a while that that's just not legally a good idea. That's not going to stand up to a court challenge. So this legislation really sort of drives that home even further. So if you're a village and you have in your zoning that you're prohibiting manufactured homes, that's really something that you want to look at and be proactive. Because if somebody comes and wants to locate a manufactured home in the village, you pretty much don't have any, you pretty much have to go by executive law and other legal precedents on that. There are other examples. Both of these examples you could probably do a whole workshop on, and there are other examples as well. This is just a couple things. Another thing that drives the need to amend these laws all the time is new uses. Always getting new uses coming down due to changes of lifestyle, changes in technology, combinations of both of those. The big thing right now is solar energy development. Particularly the large-scale solar, some people call it solar farms, utility-scale solar development. Everybody's concerned right now with those, and a lot of towns and villages are scrambling to add that standards for solar into their zoning laws. So we've worked with several communities on that. We're in the process right now of working with several communities on that. That's kind of an ongoing issue. That's made more complicated by Article 10. If people are familiar with Article 10, where some of the regulation and approval power goes to the state. There's new legislation that just came out that's changing that even further. That it's very new, and we're trying to get a handle on that at the commission to find out what that's going to mean as far as things like solar and zoning. So stay tuned on that. But there's lots of new uses. Tiny houses, that's kind of a big thing. You know, what do you do? Are there better places in your community to allow a really small dwelling? Maybe it doesn't matter. Maybe you want to have some standards for tiny houses. It's all entirely up to the community. But that's something that we're getting requests to help towns and villages with a good bit lately. Another issue is RVs, recreational camping vehicles. You know, a lot of places on Tug Hill, we're hearing about these sort of under the radar campgrounds that are popping up. Somebody has a large lot and they've got a few friends that have RVs that come up in the summer, they might come up in the winter or come down, whatever. And people are noticing that all of a sudden there's 4 or 5 RVs set up on a lot. Some people think that's great. Some people think that's, you know, causing some problems. All depends on, you know, what's going on in your town. But a lot of communities are writing regulations to sort of deal with that, to try to limit the time frame under which those can be occupied. And also trying to define at what point does 2 or 3 RVs on a lot kind of become a campground. You know, where's the threshold where there's enough of these that the town really wants to look at a site plan and, you know, better regulate campgrounds. Short-term rentals is another new thing. The internet has made a lot easier for people to rent their properties. There's Airbnb, VRBO, is that another one? We see this a lot in kind of resort areas, places like Sylvan Beach, places along Oneida Lake, Lake Ontario, you'll see this. And maybe some, you know, maybe some other places I'm not thinking of right now. But there are, you know, this has become an issue. We did have, a couple of years ago, we had a session on this at the local government conference at JCC. Communities are addressing this in their zoning. It can be very hard to enforce. Similar to the RV issue, it can be hard to enforce when you're talking about timeframes. But for something like this, you know, it is probably worth having in your zoning law, so at least you have language that can be attempted to be enforced, a standard that can be, you know, you can try to enforce it. Accessory structures is something we're seeing more and more requests about. And I'm not sure why this is, but it seems like a lot of communities are seeing more and more accessory structures being added to lots. Which is, if you're out in a really large lot in rural countryside, doesn't matter. It's a good thing, but if you're in a village, or if you're in a dense hamlet, if you're in a waterfront area, the preponderance of these can start to become a problem. So we're working with communities on trying to figure out how we handle that. Do we have a maximum number of accessory structures that are allowed? Do we have a maximum percentage of the lot that can be covered by these? Different ways to go about doing that. And once again, there are a bunch of these. Each of these could probably be its own workshop. But also in the future, the COVID-19 thing, who knows where hopefully that's going to go away soon, but If that lasts, that could have implications on zoning. The big thing that comes to my mind is the outdoor dining. A lot of restaurants really needed to switch to an outdoor dining setup in the spring, in the summer, to try to survive. And that's certainly encouraged. But that's kind of a newer thing in the North Country. So how do we, going forward here, we might try to amend some zoning laws or work with communities to amend their zoning law to allow that if they don't, and sort of, how do we require a site plan review for that? What are we thinking about in terms of how to make outdoor dining safe for the people eating and working and the people driving by? How do we make it all work in terms of zoning? Another thing I thought about recently is one thing I noticed driving around is any restaurant with a drive-through window. You'll see, those are wildly popular now, and you'll see cars backed up almost into the street in some places. So I'm wondering, is this going to have an effect on how we think about site planning for drive-through uses? Who knows? That's all going to depend on how long this lasts. But these are types of things we like to think about and be proactive about. Also, from time to time, there are new and changing ideas in the planning profession. The people that do this professionally, that write zoning laws and comprehensive plans and work with communities. A trend these days in planning and zoning is to focus more on what we call form-based zoning. So we're sort of thinking less about the use of land and more about how land is physically developed. We're thinking more about dimensional and bulk requirements, setbacks, minimum setbacks, maximum setbacks, minimum and maximum heights, architectural standards, maximum ratio of impervious surface or structure to lot area, rather than just use. And a lot of this comes out of basically when zoning first came into being in the early 20th century. Zoning is about 100 years old. When it first came into being, we were much more of an industrial manufacturing economy. So the big concern was, how do we separate your more noxious industrial sites from residential sites? How do we keep the smokestacks and the noise away from our residents? Nowadays, we have a much more service-based economy. Manufacturing is not what it used to be, unfortunately. It's also much cleaner. So we're sort of, we don't have that necessity of separating the uses. Zoning, we also found that zoning sort of took that separation too far and created uses that were so separated that we had to drive everywhere. This isn't a huge issue in the North Country, but it is in suburban areas. We had pods that were just housing, pods that were just retail, pods that were just office, and there was really no great way to walk between them. So the planning profession said, hey, we've got to change this. So that the focus now is a little more on the form that development takes. Another thing idea that's changed is parking standards in zoning laws. For a long time, it was very popular to have very detailed tables that laid out minimum zoning number of parking spaces standards for particular uses. And what that we sort of found out was doing was just creating way too much parking, more parking than was needed, which brings problems, environmental problems such as increased runoff, stormwater pollution, heat issues. When you get into a more urban area, you've got all this asphalt, you've got heat issues. So there's now less of a focus on minimum number of spaces, and we try to handle that more on a case-by-case basis through site plan review. And this is especially important in downtown areas. Even for like downtown Loudville, a lot of communities have radically reduced or gotten rid altogether of minimum parking space requirements. In downtowns, that was just creating, that was just basically more of the developable real estate in downtown was going toward parking, and less was available for actual commercial buildings, commercial mixed-use buildings, the kind of stuff that we want to have in the downtown. So there's more of an emphasis on developing your street front parking and having municipal parking lots that are the right size and in the right location. So these are just a couple examples. There are more examples, maybe sometime in another presentation. So those are reasons that you want to look at your variety of reasons of why you want to take a good look at your zoning law and maybe make some amendments. So you've decided to do that. What makes a good zoning law? A lot of things. A zoning law should include a lot of things. The first one here is a purpose statement. This is pretty common. I bet there aren't many zoning laws that don't have this, but you really need to say, why are we doing this? And this goes back to my first slide. We're protecting the health, safety, and welfare, improving quality of life, protecting important resources. Whatever you can add to that. That's going to be one of the first things that a judge will look at if your law gets challenged. What's the purpose of doing this? Why are we doing this? So next, you need a statutory authority section. This is also pretty rare to not have this, but this is where you are going to cite those planning statutes, your town law, village law, municipal home rule law, city law if you're a city. Very important to have your authority section. Next, you want a separability clause. So that's a section that says if any one section of this law is found to be unconstitutional or unserviceable, whatever the term may be, if one section is found that way, the rest of the law is separate and doesn't get included. You don't throw the whole thing out because you've got one section that's problematic. So that kind of thing saves you if you've got outdated language about manufactured homes, for one example. Definitions are a big thing. You want well-crafted definitions. You want clear, concise definitions that are mutually exclusive. You don't want definitions that sort of overlap each other. And another thing you don't want is you don't want to have regulatory language in your definitions. You want to put the regulatory language farther down in the law in the regulatory section. And we run into that now and then. I think an example of that would be if you're defining home occupation or home-based business. You might have the definition saying, home occupation is a customary occupation such as a dent, I'm trying to think of a good, what's your typical home occupation, but it's, some kind of customary occupation, such as an office occupation, real estate, financial planner, or whatever, located in a dwelling that's incidental to the main residential use of the dwelling. That's fine, but then if you go on to say that home occupation shall not be greater than 500 square feet. That's an example of trying to regulate in your definitions. You really want to take that last sentence out and put it in your section on home occupations or home-based businesses. You need to reference your zoning map. If you've got one zone zoning, this isn't an issue because you don't have the zoning map, but if you've got more than one zone, you need to have a section that references that map. And you also want to have language about how the zoning districts are defined and measured on the map, or how are they interpreted on the map. Whether they follow road lines, whether they're scaled off of the map using the map scale. What happens when a zoning boundary divides a lot into two. Zoning laws typically have a method of what you do when you have a lot that's in two zones. So you want to be clear with that. You should have a statement that any use not listed as permitted is prohibited. You want to take away those gray areas. If somebody has a use in mind that's not prohibited, but it's not listed as permitted, what do? That type of thing would typically get sent to the ZBA for an interpretation, but you can avoid that if you're clear in the law. You need good measurement methodologies as far as your setbacks, how you measure setbacks. We usually recommend that setbacks be measured from the center line of a street or road. That's usually the most straightforward way to do it. But you've got things like lot width. How do you measure lot width when you have an irregularly shaped non-rectangular lot? You can spell that out in your zoning law. Your lot depth, the same thing. How do you measure a triangularly shaped lot? There are different ways to do that. That's something you can get a lot of help with. We usually recommend that you have language and require a zoning permit. A lot of older laws will just have language that says that a building permit won't be issued unless the project conforms with the zoning law, which can work, but there you're sort of referencing a whole other law, which is the state building code. Which planning is a whole different animal than the building code. They're confused a lot, but it's a different thing. So if you require a zoning permit, that sort of gets you away from doing that, and makes record keeping, I think, a lot easier. Is easier for the zoning enforcement officer to deal with. You also have uses that aren't structural. You've got uses, say a golf course maybe, that aren't going to get a building permit. So you're not going to occupy or have those reviewed structurally. Those are just going to be reviewed as a land use, and if you have a building on the clubhouse, obviously that would be building permit, but the golf course in general, that would just require a zoning permit and probably a site plan review or a special use permit along with the zoning permit. But you want a language in there about the zoning permit. And along those same lines, we like to see language about a certificate of compliance, not just a certificate of occupancy. So there again, you're using building code language, and the certificate of compliance, that's going to apply to non-structural uses as well as structural. So if whatever you're doing is built and permitted and complies with the zoning standards, then the ZEO can issue a certificate of compliance, and that covers everything. Your zoning map itself, that's got to be clear with definable boundaries. Like I mentioned, there's got to be a way for applicants and the zoning officer to know where the boundary is. You don't want boundaries that are so complex and all over the place that it creates chaos. Flip side of that is you don't want them so simple that you're not doing effective zoning. So that really takes a lot of work. A lot of zoning laws go through a lot of revision when they're being amended, but very, very important. You need well-crafted nonconformity provisions. This is very important. You want something in your nonconformity section that deals with nonconforming uses, nonconforming lots, and nonconforming structures, which are 3 different types of nonconformity. Rather than just dealing with everything as a nonconformity, you want to set out clear standards on how each of those is dealt with. That'll save you a lot of trouble, a lot of interpretations, potential lawsuits. You want a logical process for applicants to go through. You want somebody that wants to build something in your town to be able to pick up the law and flip through it and figure out, okay, what is my use defined as? What kind of permit do I need? Do I need a site plan? Do I need special use permit? And if I do, what are the steps? What do I need for a complete application? And what are the steps I'm going to be going through as far as what's the planning board going to be looking at? Do I have to go to a public hearing? You really want to be concise with that. You don't want standards to be all over the place in your law where it's really hard for someone to figure out what they need to do. 8 o'clock, is going to get on time? Yeah,
Yeah, I think so.
okay. You don't want to include things in your zoning that aren't zoning. So we want to think back to one of our first slides. What is the purpose of zoning? Zoning, you're regulating the use of land, density of development, and the siting of structures. So if you've got something that you want to regulate that doesn't fall into those categories, you really shouldn't put it in your zoning law. And these are things like messy conditions. A lot of communities will have a messy conditions law or a junky yards law or a lawn maintenance law. You can't let your weeds grow up over 2 feet. Things like that, unsafe buildings law. These are similar to what we're doing in zoning, but they really should be on their own because they really don't fall under the authority of those town law, village law planning statutes. Another good reason to keep those things separate, well, two other good reasons. One, if you have those separate, those don't add to the bulk of your zoning law. You got to be really, and we'll get to this in the slide coming up. You don't want your law to be overly bulky. long, it should be lean and mean. If you keep these things out, that doesn't happen. And if you keep these things out on their own, then they're a little easier to administer because you don't have to go through some of the hoops that things in the zoning law do, so some zoning approvals. The 239M county review, things like that. If you're not doing something in zoning, then you can streamline a little bit as far as that's concerned. You don't want your law to be overly complicated. We've hit upon this a little bit. You want it to be relatively simple, but not too simple. I have a note here, give them a break versus complexity. A lot of communities really want to be business friendly, which is great. We want that. They want to eliminate red tape and be friendly to applicants. Also great. But the more you do that, the more you add little provisions in the law that where you might be waiving certain things for certain issues, for certain examples. The more you do that, the more complex your law gets. So there again, it's another one of these trade-offs where you really you've got to have it just right, where you're being flexible, you're being business and development friendly, but you're not creating this, this law where you're getting into too much complexity. You want to avoid redundancy. You don't want to have the same standards in two different sections of the law. You don't want redundant definitions. You really want to do everything you can to keep the law lean and mean. For a lot of reasons, it's just easier to administer. It's easier for somebody to read through. When you're copying it, you're spending less money on copies, obviously. You want your law codified into one document. So you want to be able to put your hand on, one copy, piece of paper, or one file on the internet that has everything that you've adopted in your zoning law. And this kind of happens. A lot of times, zoning laws will be amended. Small amendments will take place here and there, and those amendments that amended the language will never make it into the codified documents. And if that happens, several amendments are done that way, then you get a real mess of trying to figure out what is the actual zoning law. What's the actual adopted, enforced zoning law. So that's something you've got to be really careful with. A really neat tool where you can kind of figure out if you've got everything in one document is a Department of State has a website which has a local law search function, and I don't have the address. I can get you the address. You can also Google NYSDOS local law search, and that will pop up. But that's, I think from 1998 on, that's got every local law that was adopted in New York State. So you can go in and search by your town or village. You can go to the village of Lowville and bring up every local law that was adopted since 1998 and find out what's actually been filed by the Secretary of State, what's actually enforced in your town. That's something we use all the time as a commission to try to figure out what's going on in some of our towns. You want to make sure that all your cross-references are correct. And this is kind of hard to do sometimes. I've been guilty of missing some of these. But if you're making a lot of changes in your law and you're changing section numbers around, then you've got to be really careful and go through the whole thing and make sure that any section that references another section, that you've got the right section number in there. It's pretty easy to do with word processors these days. But you really have to make sure that you're pointing the sections of the law that point to each other are pointing to the right place, or you're going to really, I don't know, it's going to be embarrassing if you're me, if you missed that, or it's going to, potentially could cause problems. So those are some of the reasons that you would do this. And we really strongly encourage communities to get help with doing this. Don't try to do this on your own unless you've got somebody in your community that's on a committee or on your planning board that's got a lot of experience with this. And I don't say this to sound self-important, but zoning is just complicated enough that it really helps to have somebody that's done a lot of these right in at the beginning of the process to guide you through this, because there are so many ways that you can create a law that's too bulky or redundant, or the Frankenstein law comes to mind here. With the internet these days, it's really easy to go on and Google all over the place and cut and paste from other community zoning laws and put something together. We really encourage you to go and look at other communities, what they have. That's absolutely do that. If you've got an issue in your town and you want to search what others communities are doing for zoning for bed and breakfasts or domestic animals on residential lots, by all means, look into that. But we let us do the actual compiling of that information and putting it into your law. And you can get help from a lot of places for this. Obviously, Tug Hill Commission, we'd love to help you. Your county planning departments know work with this type of work with zoning laws all the time, so they are a great resource. Private consultants do this type of thing. If you've got a really complicated issue or a complicated community, there are great consultants in New York State that can really jump right in and work very fast with you if that's what you're looking for. Definitely ask for help. When you start the process, you want to do this with a group of people from your town. Some towns and villages have the planning board do this type of work. If you're doing zoning for the first time ever, you need to establish a zoning commission formally. You don't need to do that when you're amending zoning. So when you're amending, a lot of times the planning board will do the work. Sometimes the town or village board will just do the work themselves, depending on the situation of the town, how rural the town is. But you want to get a good group together of probably 7 to 9 people. You don't want a tiny group. You don't want 3. You also don't want 15 probably, because that just 15 gets a little unwieldy. You definitely want to involve your zoning enforcement officer, because he or she really is the person that's got to administer the law. They've got to deal with the public all the time coming in. They've got to have something that they can really work with. So you definitely want to involve that person. And of course, your municipal attorney. Anything that you do when you're getting these amendments together, the first thing you want to do before you get into the adoption process is run it by your municipal attorney. Sometimes the municipal attorney will be very involved in the whole process. That just depends town by town, village by village. the municipal attorney will eventually have to sign off on your local law form. So they're going to get involved either way, but it's very important to get them involved, particularly when it concerns the legality. You want them to say, yes, I can defend this law in court if need be. Going through the actual process of doing your amendment, there's a great resource from the Department of State, another PDF from the website that I referenced earlier. It's in website's in blue up top. They've got a document called Questions for the Analysis and Evaluation of Existing Zoning Regulations. So you can download this, and it's got something like 50 or 75 questions that you can just go down through that covers the things that I've talked about tonight, but in more detail. All kinds of things. Is this right? Is that right? Are you including statements on this, that, the other thing? So that's a great resource, and it's free and downloadable. So after you've gone through the whole process of getting something together as far as amendments to your law, amendments to your map, you get something that the committee likes, you get something that the town board or the village board likes, you get something that the attorney signed off on, then you go to the actual adoption procedure. And of course, nothing's super simple in this process. There's a lot of steps that you've got to go through. But you can get a lot of help with those steps. We can help you, your county planners can help you, your attorney can help you, the Department of State can help you. But we recommend that you adopt the changes by local law. Towns have the option of adopting changes by ordinance or by local law. Villages have to adopt by local law, but we recommend that everybody adopt by local law. And the reason is that the local law just has a little more weight to it. The power to enact local laws is granted by the state constitution, it's not just a power that's delegated by the state legislature. Your law is backed by the state constitution, and it has the same status as an act of the state legislature. Process is very similar, so we just say adopted by local law. So the procedure is similar to your typical local law. Communities adopt local laws all the time for all kinds of different reasons. Minimum maintenance roads, overriding tax caps, this, that, and the other thing. So it's that process, but it's beefed up somewhat because you've also got requirements that are in the planning statutes that you have to adhere to. So those town law, village law, planning statutes, they've got requirements for adopting and amending zoning that you have to comply with to legally adopt your law. There's also seeker that you have to comply with. Everybody's heard of seeker, I'm sure. So this is a list of the steps, the typical steps. We're going to go through these in detail, and we'll try to get through them pretty fast. We have an issue paper at Tug Hill that goes into detail on this. That I'll show you the link at the end of the presentation. So we'll do a town of Lowville example since we're in the town of Lowville. But you go through these same steps no matter where you are in New York State, whether you're a town or a village. So the first thing you do is the amendment is introduced by a town board member at a town board meeting. If you're the town of Loudville, one of the town board members should introduce the changes at a meeting. That's done, that's recorded in the minutes. A copy of the amendments are filed in the town clerk's office. The next thing you want to do is your seeker compliance. So the adoption amendment of a zoning law is does have to follow seeker requirements. It's either going to be an unlisted action or a type 1 action, depending on the size of what the area of what you're amending. But more often than not, it's a type 1 action. Typically, when you're doing amendments, the ones that we work on anyway, they end up affecting the entire town or village. So if you just call it a type 1 action, the town is the lead agency. The town completes the long form full EAF and makes the seeker determination. And typically that's a negative declaration. You're really, the whole point of zoning is to protect the environment. Communities aren't required to do zoning, so if you're doing zoning, you're, as opposed to a community that doesn't have zoning, you're going a long way towards hopefully protecting natural resources in the environment. With one of our zoning laws, zoning should do that. Examples. But there may be cases where you are changing zonings such that zoning that's been in effect for a long time, where you're radically loosening restrictions, where that may be considered a positive impact on the environment. That's really a case-by-case basis. This is an example of the steps for seeker. It's usually pretty simple for doing zoning. You usually only make it to step 5. But this is something that you can get lots of help with, again, from us, from the counties, from DEC. You can be guided. You can get a lot of help finding your way through this process. The next thing that needs to happen is the amendment gets sent for county planning board review. And I'm sure everybody's familiar with the 239M review, where the county gets to look at make recommendations on certain comprehensive plans, zoning laws, certain zoning decisions, site plan reviews, special use permits. So the county's going to be looking at your zoning law, and they're really going to want to focus on how is this law going to affect county properties and assets and policies. How is your zoning law going to affect development along county highways? How is it going to affect county properties, county buildings? So they're going to do their review. That's also great to just get another set of eyes or several more sets of eyes on your law. A lot of times they will catch little mistakes that we've missed. They might catch some cross references that are wrong, or they might say, hey, you forgot some separability clause, things like that. So we really look forward to seeing their comments. So you send them the amendments. You send them part 1 of the EAF, like you would for any other submission to the county planning department. They have 30 days to do their review. 30 days, or they have up until 2 days before the town board's final action. So you don't hear anything from the county, which is highly, highly, highly unlikely then the community's free to just go ahead without that recommendation. So then the town board has to hold a public hearing. And there's all kinds of requirements on how you do the notice for the public hearing. And these are in the statute. There's a number of steps. You've got to put notice of the hearing in the newspaper of general circulation in your community at least 10 days prior. You've got to send notice to the clerks of any municipality within 500 feet. So that's going to be any bordering municipality. Or it technically could be if you're a town and you have a bordering town that has a village that's somehow right on the edge, but not on the edge of the town and within 500 feet. They get the notice. So for our town allowable example, it would be the towns of Denmark, Harrisburg, Martinsburg, New Bremen, Watson, and the village of Lowell. You get notice to them. You get notice to the clerk of the county legislature. So the clerk of the Lewis County Legislature, also 10 days. You're also required to send notice to, if you've got a state park or a housing authority property that's within that distance. You're required to send notice to, and it's in the statute exactly who you send it to. Required to notice them as well. So you setting your date for your public hearing. As far as what days count in the 10 days, we get this question once in a while. The day that the notice is published in the paper doesn't count, but the day that the hearing is held does count. So that 10 days starts the day after it's published, and it does go and include the day of the hearing. So that's what's required in statute. But your community really ought to be thinking about getting the word out, going the extra mile if they want to, and getting the word out to people that don't read legal notices in the paper. They can do a press release. They can do an article on the website. They can post things around town, social media. We had a workshop sponsored by Tug Hill back in it was July or August. That was all about how do you increase public participation. I think the workshop was called Increasing Transparency in Planning Procedures, something like that. You can watch that on our YouTube channel. You can get to that on our Tug Hill website, where we've got YouTube videos of prior workshops. I think that's one of them on there. So yeah, that depends. If you want to get extra word out, you're not required to, but it's a good idea in a lot of cases. So you hold your public hearing. Who comes to that? That can be, depending on the community and what's going on in the community, that can be nobody. That can be 2 people. That can be 50, 60 people. That's all going to depend on, every situation is different. But you're required to let anybody that wants to speak, regardless of who they are, where they live. You certainly can set up rules and decorum to have a well-run hearing. Minutes must be taken of the hearing, and they must contain at least the general details of what each speaker said. Again, another really good resource from the Department of State from that same webpage. They've got a good paper on conducting public hearings and public meetings. This is great resource for planning board people, town board, village board, ZBA, whatever. This gives you a lot of information on how to run a good meeting, what you have to do, what you should be doing, best practices, whatnot. So when you've got all of that done, the board can adopt the amendments. Although to adopt it, there's a requirement that the law must have been on the desks of the board members at least 7 calendar days exclusive of Sunday. Or it's got to be mailed to the board members at least 10 calendar days exclusive of Sunday. So you've got to have that requirement met before you do your adoption. Going back to the county review, if the county makes recommendations and you are on board with all of them and you are putting all of them into your law, then you just adopt the law with a simple majority of the board members. If you're not going to include those, if you, for whatever reason, don't feel that they're necessary or somebody disagrees, if you want to adopt contrary to those recommendations, you need a supermajority vote of the board. So you need a majority plus 1 to adopt. There's also a little part in the statutes that say if citizens aren't happy with your changes, they can submit a written letter that will force the board to adopt with a 3/4 vote of the board. This is detailed in the statutes. This is in town law and village law. And it's here on the slide. It's the owners of 20% or more of the area in the included change. If they're not happy, they can force this sort of extra majority vote. Also, if the owners of 20% or more immediately adjacent to the land, or if the owners of 20% or more of the land directly opposite to the change, extending 100 feet. This happens very rarely. I don't know if I've ever known of it happening since I've been working at Tug Hill. That's not to say it hasn't, but this is pretty rare. So the board then, after adoption, they need to report to the county planning department or county planning board their action and how they dealt with the recommendations of the county. And if they've acted contrary to the county recommendations, they need to set forth the reasons why. This is another step. But it's something that you need to be doing. The next thing, the town clerk files the law with the Secretary of State. There are local law forms that you can get. A standard form that's typically a lot of times filled out by the town attorney, the municipal attorney, where you're lots of blanks to fill in, and then you include the new language of the law. When you're filling that out, you're not supposed to include deletions or strike-throughs, underlines, italics. You're just supposed to include the new information. That's the new section as it is changed. A lot of times there'll be so many changes. There'll be such a complete overhaul of the zoning law where section numbers change that just a brand new law will be submitted. That was done when the village of Lowville did a very large amendment to their zoning law back in 2015, 2016. So that's, either way you do it, that goes to the Secretary of State. If you do it right, they will accept and file the law. If you do it wrong, they'll send it back and tell you why. And the law becomes effective when it's filed by the Secretary of State. So a copy of the law is entered into the minutes and filed with the town clerk. So very, very important that the town clerk has a file, a separate file for every version of the zoning law. Every amendment should be, somebody should be able to put their hands on every amendment that was done since the zoning law first was amended in your community. And that comes into play when you've got situations with nonconformities. You want to be able to know what the law said way back when, in 1994 or whatever. Going forward, you want to have all of that on file. The summary of the law is published in the newspaper and posted at the main entrance of the clerk's office. So that can be just the title of the law, what the purpose is, what it's about, what the changes were. So that's a lot of stuff. But once again, you can get, there's lots of help available to guide you through the process. A lot of communities will just want to jump right through, skip some of those hoops. You really shouldn't be doing that. You should be jumping through all of them. For more detail, we've got an issue paper, adopting and amending zoning by local law, that you can download as a PDF that will go through all those steps. If you really want to do the deep dive and really learn a lot about adopting local laws in New York State, there's a Department of State publication at that same DOS website, Adopting Local Laws in New York State. That's going to give you all kinds of background and information on the whys and the hows of adopting local laws. That's all I have. Thanks again, everybody, for coming out in COVID conditions and not a very nice night here in Loudville, but at least it's not snowing. So yeah, it's about 8:30. So any questions? I'll try to answer. Yep, all the way in the back.
Go back to the manufactured home, New York State Executive Law 616.
Yep.
For definition, let's use the word trailer. If they want to put those on a foundation, are they allowable use?
We believe so. You're talking about a very old, like a pre-1976?
I'm talking about a new one.
A new one, yes.
No, I'm saying, does a slab count as a foundation, or does it have to have a cellar?
I believe a slab does not,
Okay.
but that I can double check on that for you. Yeah, any question I have trouble with here, which is quite possible, I can.
A lot of zoning laws outlaw those.
Yes.
They're permitted. They're not
Yes.
permitted.
Yep, you really got to be careful with that these days.
Right.
But yeah, that's anything with a HUD seal, a mobile home, a manufactured home. There again, the definitions get really confusing. But that's any post 1976 HUD seal manufactured home, and we think any pre 1976 as well has to be treated the same way.
Okay.
Doug?
Yeah, on the section you had here, you said the law becomes effective after filing on the Secretary of State. I understood that that's not true. You got to hear back from the Secretary of State, right? Before it's. You gotta get something back from the Secretary of State before it's technically law.
That could be, I know you get a postcard back that says it's been accepted and filed.
Okay.
Let me look into clarification on that.
Because I know that just sending that to the Secretary of State does not make it law.
Right, it's gotta be accepted and
So
filed.
they must have to send something back.
Yeah,
to say,
yeah, it gets accepted, filed, and stamped with the dates. But let me, I'll get full clarification on that.
Now we got a couple of questions online. Paul Feaster says, is there a timeline to which a comprehensive plan needs to be updated? Ours is dated 1966. You did touch on this a bit.
There isn't a statutory number. It's highly recommended that it get updated every 5 to 10 years, 8 years. The ones that we've worked on, 5 years is probably the quickest they ever get updated. 8 to 10 years is more common. But that again, that would really depend on best practices, how complicated is your community, and what's going on. Is it growing rapidly? Is there nothing happening?
Mm-hmm.
But you should state in your comprehensive plan, you should put in a time frame. And we try to do that, saying this plan should be revisited in 5 years, 8 years, 10 years.
Mm-hmm. Another question, should the zoning enforcement officer include deed restrictions when issuing a permit?
Deed restrictions on typically that would be an optional thing, I guess, that really, deed restrictions don't really have anything to do with zoning. Restrictive covenants, that's a separately enforced issue than zoning, and the municipality has no power to enforce deed restrictions.
Mm-hmm.
Those are often required if you're doing a site plan review. It's pretty common to require that an application, a site plan show rights of way and deed restrictions.
Mm-hmm.
But I'm not familiar with that being listed in a permit issued by a CEO.
Right. Our next question is from Carl DeFranco. He said, would having a progressive approach to accessory structures be an acceptable method? For example, 2 accessory buildings per each 5 acres up to some number.
Yes. Yep. Yeah, you can do that type of thing, like a sliding scale. We're working with the town of Parrish right now on that type of standard.
Great. Our next question is also from Carl, is that should a zoning law include things like cell tower placement, size, solar installation siting? And he says that, I'm aware of new New York State solar siting regulation, but it does allow local governments to have requirements as well.
Yes, absolutely. You absolutely want to have cell tower regulations in your law, solar regulations in your law. For the larger projects, there are state and federal laws that exempt a lot of what a local municipality can do as far as control. But for smaller, you still need those regulations for the smaller developments, and having them in there, your state level review boards are supposed to take those into account.
Mm-hmm. All right, we got another question. I think it was about, it's about seeker. Is a seeker process really required for simply word changes like 2 copies versus 5 copies of something. I'm assuming they're speaking about the application, site plan application, something along those lines.
Right, yeah, I'm not a seeker expert, but probably not, or it would at least be an unlisted use. Let me see, I'm looking at my notes here. Yeah, for zoning to be considered a type 1 action for changes, it's got to be the adoption of changes in the allowable uses within any zoning district affecting 25 or more acres of the district. So there you're talking about changes in the allowable uses, making it a type 1. If it's not that, it would be an unlisted action. So you should be able to dispense with the seeker review pretty quickly and easily.
Right.
But that's a good question, and I'll try to get a more refined answer on that.
Cassie Buell says, great job, Tug Hill. As a reminder from the Lewis County Planning Department, please make sure to send us a copy of your adopted zoning law so that we can have them on file. Thanks, Cassie.
Yes, very good comment. Yep, so that's your Lewis County Planning Director. So she could be lots of help in this whole area, and yet do send your changes, your adopted zoning laws to the county so they can keep track of them. They put them on their website, which is very handy as well.
All right, another question from Carl DeFranco. He says, regarding the bullet on site conditions, I think this came up earlier in your presentation, but he says on site conditions versus site use, does that imply that towns should enact local laws to regulate those things if they want such control?
Site conditions is that like a messy conditions and?
I'm not positive.
There was a slide where it said don't put these things in your zoning as far as if it's a messy condition,
right,
or junky yards or unsafe buildings. Yes, municipalities should absolutely, they should adopt those local laws that regulate those things. It's obviously up to the community, but certainly that's a pretty good thing to have in your law, so you can enforce, so you don't have detriment of property values and unsafe conditions and et cetera, et cetera.
We've got a comment on the deed question we had a little bit earlier. Carl DeFranco says that deed restrictions are contract law, not zoning law.
Right, it's a different, similar but different animal.
Right. And his example was to the previous question was, we have an old house that's collapsing. Is that a zoning issue or a safety issue?
That's typically not covered in zoning. A lot of municipalities have unsafe building laws that regulate that type of thing. You're really talking about the condition, the condition of land rather than the use or the development or the configuration of development.
And I think our last question then would be, does it matter if the enforcement clause, if it goes in the latter part of the document or in the beginning of the document?
It's the laws that I've seen, it's always at the end. I wouldn't think it would matter, but that's typically at the end along with the other administration sections about what requires a permit, and a section about the ZBA and appeals and variances.
Great. And I guess I'll just add that we've got a lot of good presentation. Thanks. Good information, very helpful. A lot of really great feedback from everyone online.
Great, glad to hear it. We are doing a series of these to try to make up for the local government conference that no one could go to in April. So we have on our website information about those, also Tug Hill Times, we're advertising those. There's a session Thursday night in West Carthage on ZBA basics. And that's a hybrid in-person Zoom as well. So if you're interested in that, I believe you can still sign up for the Zoom part of it.
And we've got a raised hand but from Tom Valentine. I'm going to see if he wants to speak. Hi, Tom, you're unmuted.
Hi, I forgot to unclick click the lower hand, so I'm done.
Okay, thanks, Tom.
But I just came back in the room for a second. I heard West Carthage. What was that?
You heard West Carthage?
I thought I heard West Carthage.
You mentioned something about West Carthage? About the training on Thursday?
Yes, the training on Thursday night in West Carthage, I believe it is.
Yep, that's correct.
On zoning board of appeals basics.
I'll be there.
But all are welcome.
Wonderful. Thanks, Tom. All right, guys, well done.
All right, thanks, everybody. Take care.
You.
I've got your certificates, guys. Don't you leave too quick.